Do you think the International Court of Justice, ICJ, will give fair judgments? That's what it's supposed to do, but guess what? Someone is influencing it. After the ICJ decided on the South Africa case involving Israel's actions, it became clear that nobody wanted to stop genocide. To teach South Africa a lesson about supporting innocent people, Justice Julia Sebutinde, an African woman, had to go against South Africa's requests. But who made her do that? Does her decision even make sense? Let's find out. On January 26, 2024, a significant event occurred at the International Court of Justice, ICJ, as it issued a ruling in response to South Africa's genocide case against Israel. The verdict mandated Israel to undertake specific measures aimed at preventing and penalizing acts of direct and public incitement to commit genocide. This decision, however, has not been universally embraced, particularly by South Africa, giving rise to a contentious debate. The controversy deepened with the notable dissenting vote of Justice Julia Sebutinde, the first African woman to serve at the ICJ. Her opposition to the ruling added a unique dimension to the address surrounding the case. Numerous experts in the field have stepped forward to scrutinize both the overarching decision and Justice Sebutinde's stance, encouraging a climate of criticism. Beyond the general critique of the verdict, Justice Sebutinde herself has become a focal point of scrutiny. The reasons behind her dissent and the subsequent reactions have fueled further examination of the case. But why is she being criticized? Did she do anything wrong? Here's a reminder to please like and share the video and subscribe to our channel to watch more videos on Africa's geopolitics, economy, and changing landscape. Let's continue now. After we tell you what she did, we will leave it to you if this was right or wrong. Let's first talk about the decision given by ICJ to understand what role Sebutinde played in this. The International Court of Justice, ICJ, delivered a momentous directive, commanding Israel to take immediate action to prevent its armed forces from breaching the Genocide Convention. The aftermath of this groundbreaking decision has reignited calls to suspend weapons transfers to Israel, with advocates claiming that such transfers amount to complicity and represent a clear violation of international law. The ICJ's directive is expected to spark vigorous debates surrounding the role of individual judges and their allegiances within international legal institutions. The ICJ's directive against Israel emphasizes the global community's commitment to upholding international humanitarian principles, particularly in the face of alleged violations of the Genocide Convention. The court's emphasis on preventive measures signifies a shift in approach, emphasizing proactive steps to end potential atrocities rather than merely reacting to ongoing conflicts. The court's ruling emphasized the crucial nature of Israel's commitment to countering incitement to genocide and providing increased aid to Gaza to ease challenging living conditions. This aspect of the ruling acknowledges the humanitarian aspect of the conflict, emphasizing the responsibility of nations to ensure the well-being of civilians affected by geopolitical disputes. The court's decision aligns with broader international efforts to prioritize the protection of civilians in conflict zones and address the humanitarian consequences of armed conflicts. Notably, the ICJ refrained from mandating a ceasefire. They also said that it would take them years to identify if this was a genocide. Until then, they couldn't order a ceasefire. That means even if this is a genocide, it will continue for years. What role has Justice Julia Sebutinde played in this? In a departure from her colleagues, Justice Julia Sebutinde of Uganda emerged as the second dissenting voice in the International Court of Justice, ICJ, voting against all 6 provisional measures approved in the South Africa genocide case against Israel. The measures, which aim to address various aspects of the conflict, included orders for Israel to combat incitement to commit genocide, cease obstructing aid deliveries into Gaza, and take immediate steps to prevent its armed forces from violating the Genocide Convention. Justice Sebutinde's dissent has drawn attention for its unique stance in opposing emergency orders against Israel, raising questions about the rationale behind her decision and its potential implications for the broader legal landscape. One of the key provisions that Justice Sebutinde voted against was the order for Israel to prevent and punish incitement to commit genocide. Her dissent in this matter raises criticism. While most of the ICJ emphasized the need for proactive measures to curb potential atrocities, Justice Sebutinde's stance prompts reflection on differing interpretations of the gravity and impact of incitement. Similarly, the order for Israel to stop obstructing aid deliveries into Gaza was met with dissent from Justice Sebutinde, Perhaps the most contentious aspect of Justice Sebutinde's dissent was her opposition to the directive for Israel to take immediate measures to prevent its armed forces from violating the Genocide Convention. This measure was a central focus of the ICJ's response to the alleged violations in the South Africa genocide case. Justice Sebutinde's disagreement raises fundamental questions about the interpretation of evidence, the threshold for judicial intervention, and the appropriate balance between national sovereignty and international legal obligations. The dissenting opinion of Justice Sebutinde also prompts broader reflections within international legal institutions. As the only judge from Africa to oppose emergency orders against Israel, her vote highlights she is taking a stand against the nation she is from. In this legal phenomenon, Justice Julia Sebutinde's dissenting stance on all 6 counts added a layer of complexity to the narrative. As the first African woman to grace the ICJ, Sebutinde's role became pivotal in questioning the unity of the court. Her dissent prompted a closer examination of the autonomy and responsibilities of judges within the ICJ, especially in navigating complex legal scenarios. People are asking the reason behind her decision. Why did she stand with brutality and against innocent people? So why did she, being from Africa, stand against South Africa? To understand the weight of Sebutinde's dissent, it is crucial to delve into her legal history. Serving her second term at the ICJ since February 2012, Sebutinde has a track record of making dissenting decisions. Notably, her involvement in the case concerning Uganda's stance on the Democratic Republic of Congo showcased her willingness to challenge the majority decision. Exploring her previous dissents provides context to her approach and mindset when faced with complex legal disputes. How has Uganda responded to this? The unexpected dissent of Justice Julia Sebutinde has sparked a significant response from the Ugandan government, leading to her disownment for taking a contrarian stance against emergency orders directed at Israel. In the aftermath of the dissent, questions about the motivations and factors that influenced Sebutinde's decision-making have emerged. What made her make these decisions? Unlike her fellow judges who accepted South Africa's arguments, Sebutinde stood firmly against everything South Africa's legal team presented. This departure has prompted speculation about whether external forces controlled or influenced her. The nature of her dissent has fueled suspicions and raised eyebrows within legal and political circles. One key aspect that remains puzzling is what prompted Sebutinde to take such a decisive stand against all 6 measures. Critics scrutinize whether personal beliefs, political considerations, or external pressures drove her vote. The controversy surrounding Sebutinde's dissent has ignited a broader debate about the independence of judicial decisions and the potential impact of external influences on the legal system. As the Ugandan government disowns one of its justices, the internal and external reactions to Sebutinde's dissent add another layer of complexity to an already contentious issue. The scrutiny of her motivations highlights the delicate balance that judges must navigate between personal beliefs, external pressures, and the pursuit of justice. The fallout from this dissent may have far-reaching implications for the perception of judicial independence and integrity in Uganda's legal system. Sebutinde's dissent, within the broader context of the Israel-Palestine conflict, adds another layer to the controversy. Characterizing the dispute as primarily historical and political, she challenges the notion that it is sensitive to legal resolution. This perspective has sparked considerable debate among legal experts and scholars who argue that genocide, by its very nature, is a legal matter, irrespective of the historical and political complexities intertwined with such disputes. Legal experts, including Mark Kirsten, an assistant professor specializing in human rights law, emphasize the importance of recognizing the legal dimensions of the matter while acknowledging the historical and political context. Kirsten asserts that both South Africa and Israel willingly signed the Genocide Convention in 1948, thereby acknowledging the court's jurisdiction over breaches of the convention. The decisions ICJ gave make no sense now. Not calling this a genocide is like giving a green signal to Israel to do more. While experts are confused about this decision, what reaction can you expect from youth on social media? Sebutinde's dissenting vote in the South Africa-Israel genocide case has not gone unnoticed by the public. Social media platforms have become a battleground of opinions, with many openly questioning her motives and judgment. Some voices have labeled her an embarrassment to her country and a disgrace to humanity. The Ugandan ambassador to the United Nations clarified that Sebutinde's ruling did not align with the official position of the Ugandan government on the Palestine situation. The questions remain. Why did someone from Africa practically stand against all the measures South Africa presented? There is more to the story that happened behind closed doors. The recent decision has shown discrimination against people from the international justice system, suggesting most of the institutions are controlled by some external actor. Do you agree with Justice Julia Sebutinde's decision against South Africa? What could have influenced her choice? Is someone controlling her actions? Let us know in the comment section who you think can be pulling the strings. Do you want to watch more videos like this one? If yes, subscribe to our channel and press the bell icon next to it. We have decided to bring videos on something nobody talks about: African politics, economy, and increasing power. Thanks for watching, and until the next video, stay tuned.
Tell us what you think in the comment section. Like and share the video, and subscribe so that you don't miss any of our African videos. It's the best way to support us.